Hi, thanks so much for joining our webinar this morning. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Kyle Cassidy, a New Jersey construction lien law guru. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Kyle Cassidy.
Thank you very much for the introduction. Good morning, everyone. I hope you're all having a wonderful day. As just discussed, we will be talking about, really what matters, getting paid on these projects and the mechanisms to do that. Paying specific attention to New Jersey law. Before we begin our presentation, though, let's just go through some ground rules. If you have any questions at any time during the webinar, there's a chat box to the right. You can provide those questions, and at the end of the presentation, I'll answer wherever I can. Just don't include your names or your company names in the questions, but feel free to ask any questions that you have. So today's agenda. We'll start by talking about the contract and what we can do with your contract in order to help facilitate and expedite getting paid. Next, we'll talk about lien rights and what any claimant should do in order to protect those and secure those lien rights. Then we'll talk about bonds, which are another form of recourse that claimants might have to get paid. Then the next thing we'll talk about are some traps to avoid, considering both liens and bonds, and just in my experience, things I've seen happen that can cause problems to securing those rights, particularly, and as we'll see, where there's very black and white requirements that must be followed. We'll also talk about the New Jersey Prompt Payment Act, which is a statute in New Jersey that actually includes a lot of beneficial timing components to when payment must be made, and it provides punishments or essentially a leverage for the claimant to help get paid against a owner or a general contractor upstream. Then we'll talk about, once the agreement to get paid is made and there's a check in place, what should be done around that time in order to make sure you're not compromising rights that you may have upon receiving that check. And then lastly, we'll talk about SunRay's resources and ways that you can take advantage of SunRay to secure your lien rights, secure your bond rights, and ultimately facilitate getting paid. Getting paid faster through your contract. So some important considerations to considering just when you're signing up a client to do work. This may seem obvious, but one thing that all contractors should have is a written contract. Believe it or not, there are a fair amount of times where that is not the case. For one reason or another, a contractor may think that there's a business relationship with someone or a handshake deal is sufficient, and technically, yes, under the law, an oral contract is enforceable, but an oral contract will not allow you to, and as we'll talk about, will not allow you to have all of your rights. In particular, you will not be able to file a lien if you do not have a written contract. And what is a written contract? Well, it's obviously something in writing, and it's something that's going to specify what is the services that are being performed, what the cost of those services are, and really an important thing should be is that it's signed by the person who is signing up the contractor, who's agreeing to be bound by the contract. In a typical oral contract situation, if you're actually trying to get paid, you perform services for somebody, and all you have is a handshake deal, there may be some difficulty in proving exactly what the agreement was. What was the compensation that was agreed upon? what were the terms and of when the work was supposed to be performed. All of that would be just left to a he said, she said situation. So in order to avoid that troublesome problem, which can really jeopardize your ability to get paid, you really need to have something in writing documenting what's being performed. Terms that should be included in the contract are the payment terms, obviously, and the conditions of payment. Is payment going to be made within a certain amount of days upon receiving an invoice? Does the contractor need to submit a lien waiver or other sort of documentation in order to be paid? Obviously, as the contractor seeking to be paid, in the contract negotiation, you're going to want to limit the conditions that are upon you in order to get paid. And conversely, the owner or general contractor is going to look to make as many conditions as possible. So, without getting into too many specifics, just generally, when you're negotiating a contract with the other party who's going to be paying you, you're going to want to provide terms and conditions that are going to provide for the least amount of time possible for you to get paid, and limit any conditions that may be onerous on you or time consuming on you to establish in order to get paid. Another thing to consider is if payment is not made, you should have a provision in the contract which provides for interest on the sums that are due and owing, attorney's fees and costs if you're forced to ultimately file a lawsuit to recover those payments that are due and owing. And going back to the one thing to pay particular attention to is in New Jersey, there's a clause known as a pay if paid clause. And what that clause is it says that the payment due to you, meaning the contractor, from in this scenario, let's say it's an owner general contractor situation, or we'll say it's a subcontractor general contractor situation. I'm sorry. If the general contractor includes language in its subcontract saying that your payment is conditioned upon receipt of payment for your work by the owner, then and that's an express condition precedent to the payment to the subcontractor. If that language is in your subcontract, then in order for the subcontractor to get paid, the owner would have to pay the general contractor the money due and owing to you. And as we all probably have experienced, there's very frequently situations where, for whatever reason, the owner takes time to pay the general contractor, and in turn, the subcontractor is left unpaid for its work. Well, if there's this express provision in the contract which entitles this general contractor to hold payment and conditions payment upon receipt of payment from the owner, then the subcontractor is left high and dry and without being paid until the general contractor ultimately gets paid. So if you see this types of language in your subcontract, and it could also happen in a general contractor owner situation where payment is conditioned upon a lender making payment to the owner. If there's a construction loan and the lender, takes time in order to issue payment to the owner, then the general contractor would also be similarly tied up and would have to wait until the lender pays the owner in order for it to receive payment from the from the owner. And if there's any questions about that aspect of things, feel free to type that into the screen, and I can address any additional questions on that issue, because it's a very important issue in New Jersey, considering these clauses are enforceable. Lastly, ADR provisions. What's an ADR provision? Alternative dispute resolution. So things like mediation, or ultimately an arbitration, a different form of litigation, which is binding. But mediations are frequently referenced in any contract and construction as a condition to dispute resolution, whether it be a lawsuit in court or an arbitration before a private dispute resolution forum like the American Arbitration Association, JAMS, or any of the others that are out there. The benefit of a mediation provision, which again, it would require the parties to first mediate and negotiate their claim before they could even file a lawsuit. The benefit to that is you actually get an opportunity to sit down with the other side with a neutral, a person who's going to try to get the case settled and meet individually with both parties to try to work through their dispute to get it resolved. The problem, though, could sometimes be is you may know in advance that there's no way the other side's going to agree to pay, and the mediation will just turn into a waste of time. Obviously, at the time of contracting, you can't really predict that, but frequently these mandatory mediation provisions can be a benefit, but they can also be another impediment to getting paid, because it just creates another roadblock to getting to the point where you're ultimately able to file a lawsuit and prosecute your rights. All right, now we'll jump to the next topic, which is securing your lien rights. Generally, what is a lien? Well, a lien is an encumbrance on the actual property, and it's a mechanism that will cause a lot of problems for the owner of the property. It may impede their ability to get a loan. It could ultimately result in a foreclosure action where title of the property could be jeopardized. So it's a very strong mechanism that all contractors and subcontractors should take advantage of if they're not getting paid and want to exert leverage to get paid. The important thing, and we'll talk a little bit about this in a second, is liens are something that must be contemplated and understood throughout the project, the possibility of filing it, because if you miss your deadline, which is a very tight window, then you can't file it. So while I'm talking about it, I'll jump to that right now. That's the second point here, the deadlines. For a non-residential lien, construction lien, meaning a project that's not owner occupied, it's not a single family residence, it's maybe a commercial building, it's a bricks and mortar shop or something of that nature. If you're doing work for a non-residential private construction, then you have the benefit of filing this construction lien, but it must be filed within 90 days from the last date of work. So if it's the 95th day or the 100th day, you're out of luck. If it's the 91st day, you're out of luck. So you can't wait to file a lien. You need to understand that your rights are expiring as soon as you leave the job, and file a lien as soon as possible, because otherwise you won't have that right. For residential properties, meaning the typical example is a single family home, you must file what's called a notice of unpaid balance within 60 days from the last date of work. And a notice of unpaid balance is a somewhat similar document to a lien. It provides the same notices that are identified above the lien contents. It identifies the name and address of the claimant, the property location and the lot and block, the owner of the property. If there's a general contractor and you're a subcontractor filing suit or filing the lien, it would identify who the general contractor is in addition to who the owner is. What the interest is of the property. Did you do work for the owner itself, or did you do work for a general contractor who was hired by the owner itself, or were you working for a tenant of the property? In which case, then it would be a leasehold interest. The contract information, the date that the contract was executed, what work was performed thereunder, That'll be in the lien document or a notice of unpaid balance document, an accounting of the actual amount that's due, and the accounting will include, the base contract, any approved change orders. Now that's particularly important because you can't file a lien if it's a disputed change order, or if there's not an actual written document signed by the other party agreeing to a change to the contract. So if you have a contract for $100,000 and then at some point during the project, there's a conversation about building a retaining wall, and the retaining wall is going to cost another $10,000. And it's just a simple conversation in the field. You go out and buy the materials and build a retaining wall. Well, if there's no written change order to document that change, and it wasn't signed by the party who approved the change order, then that won't be able to be included in the lien and included in the amount that's stated as due and owing in the lien. So going back to the initial slide about importance of writings and importance of contracts, change orders should absolutely be in writing and should be absolutely signed when they are approved by the other side, and they should be they should always be descriptive of the work being performed and essentially be a mini contract of themselves. Going back to the lien accounting, so you have the base contract amount, the approved change orders, any credits that may have been agreed upon by the parties should be applied, and then ultimately the amount paid and what is due and owing. Lastly, and this goes back to the deadlines, the last date of work performed or materials delivered needs to be stated in the lien documents, because again, that's going to be important to understand whether or not the lien itself was timely filed. One other important aspect of the lien law is with respect to your proximity to the owner. Only first, second, and third tier claimants may file a lien. So a first tier claimant would be a owner general contractor relationship. The second tier would be a general contractor hiring a subcontractor relationship. A third tier claimant would be a subcontractor hiring another subcontractor or a supplier. Beyond that, if you don't fall into any of those three tiers, if you're not a general contractor, subcontractor, or a subcontractor, then you have no ability to file a lien, a construction lien. Similarly, if you are a supplier to a supplier, meaning if you are supplying fencing materials to the project, or if you're supplying metal materials to a fencing supplier who ultimately supplies just the fencing materials to the project, then you as the material supplier to the fencing supplier would not have lien rights. Lastly, regarding the actual way in which to record the lien, it must be submitted to the county clerk where the property is located, the property where the lien is being filed. This is important because it adds to the time component of things, where if you wait too long and you're on the 88th day and you're starting to repair a lien, then you're going to be more subject to the whims of the clerk's office, how they operate, and any issues they may have. For example, in Hudson County currently, if you're going to file a lien there, in my experience recently, they created a new policy where, I think this was born from COVID, where you need to actually have a appointment with the clerk in order to file the lien. So you just can't simply prepare the lien on the 90th day, walk into Hudson County, and file the lien. They'll tell you you have to come back when you can get an appointment. Obviously, that's a big problem, because if you don't have an appointment, and it's the 90th day, and you're not going to get an appointment until a week from then, you're going to have a significant problem getting that lien recorded. So, I'm aware of other situations where sometimes the courts are closed, or the clerk's office is closed for some particular reason, whether it be weather related or whether it be, during COVID, I was involved in a case where someone filed a lien and they went to the clerk and they wouldn't accept the lien because of COVID protocols that were in place. So, this all goes back to the time aspect of things. Anytime you leave yourself less time to file these liens, you put yourself in jeopardy of either not being able to timely file it because of one reason or another. And it could be as simple as not having an appointment with the clerk's office and not knowing that an appointment was required. You can file liens by mail or overnight delivery, but again, in order to do so, you need to leave yourself enough time for that lien to get there, and then for that lien to be opened, reviewed by the clerk, and ultimately recorded. Also, when it comes down to the time aspect of things, if there's some technical issue that's with your lien and they identify the lien and reject it for some reason, if the lien is attempted to be recorded on the 30th day from the last day of work, you still have 60 days, assuming that it's a non-residential job, to correct that defect and file and record the lien. But if you're doing that on the 85th day and you now need to try to hustle to remedy the defect, that's going to be a problem. So I can't stress enough the importance with which you really need to always be cognizant of the limited time frame that you have to file liens, and if you're going to file a lien, do it sooner than later. Additional requirements. So once the lien is actually recorded and you get it back from the clerk, well, you need to serve it. You need to serve the lien on the property owner, the individual who owns a property that now the lien is against, and any general contractor or subcontractor included in the chain of contracting with which the claimant is part of. So if a subcontractor files a lien on a job, then the subcontractor will need to serve the lien on the owner and also serve the lien on the general contractor. And it must be done within 10 days of the lodging again. And it could be done by certified regular mail. It could also be done through a process server. The statute lays out the specific ways in which it can be served, but certified regular is very typical. If you don't serve the lien within that time frame, it doesn't necessarily preclude you from being able to enforce the lien, but if there's some prejudice that would be borne by not receiving the lien, and the other party could show that would be the standard that would impact your ability to enforce the lien. And ultimately, service must be effectuated before you could seek to enforce it via foreclosure action. So if it's not made within the first 10 days, it could still be done, and it must be done before a foreclosure action can be commenced. Regarding the statute of limitations to file a lien foreclosure action, the lawsuit must be brought within 1 year from the last date of work. This is important because it's not 1 year from the date you filed the lien. It's again ties back to the last date of work or the last date that materials were delivered to the site. And I'm actually involved in a case right now where someone made the mistake where they filed the lien foreclosure action believing they had 1 year from the date of the lien being filed, and now they're at a point where their lien and their lawsuit to foreclose the lien are untimely, and they will not be able to foreclose the lien. Talking about just another, we talked about the notice of unpaid balance before. This ties back to residential projects and the difference between the construction lien process on residential versus non-residential. The reason for that is that they don't want people filing liens willy-nilly against other people's homes and residences. There needs to be some check and balance, New Jersey decided, in order to be able to file the lien. And what the process is the notice of unpaid balance is filed first, and it's essentially has a lot of the same content of a lien, but it must be filed within 60 days. So if you're a contractor putting a deck on someone's home and the owner doesn't pay you, well, your recourse is not the construction lien initially, it's the notice of unpaid balance, and it's within 60 days of the date that you completed your work on the deck. The next step will be, once you've filed that notice within the requisite time, there's a process, it's an arbitration process oversaw by the American Arbitration Association. And that arbitration process is fairly basic. All they're really doing is making sure that the technical requirements have been complied with and that you have a colorable claim to assert and to the unpaid amount. It's not going to be their determination in the arbitration is not a determination on the merits of the underlying amount due and owing. All it's doing is making sure that the technicalities have been complied with in order to assert the lien. And if the arbitration process is successful, then the lien can be filed. But again, if you're asserting that lien, it doesn't mean that you automatically have proven your entitlement. It just means that you have the ability to get the lien. So the way I would think about it is there's an intermediary party who's just double checking to make sure that what you're filing is actually legally compliant. If you're doing work on a public job, and when I say public, specifically, a municipal lien. So if you're doing work for a county, a municipality, a city, a water commission, then you can file what's called a municipal mechanics lien. The difference between a construction lien and a mechanics lien is the construction lien, you could actually file a foreclosure action, and the property and the title of the property would be subject to the lawsuit. If it's property owned by a municipality, well, you can't foreclose on the municipality's property. But what you can do by filing this lien is it'll prevent the money that's allocated to that contract from flowing. So if there's a $2 million job that the county is hired a general contractor to perform, and you're a subcontractor under that general contractor, and you file a lien against the contract, well, then all those contract funds are going to stop flowing to the general contractor from the county, and that's obviously going to be a leveraging point for the subcontractor to get paid from the general contractor. A lot of the same lien contents are required. The filing deadline is a little bit less strict. The lien can be filed anytime, while work's being completed, or within 60 days after acceptance of the work of the project by the owner. In addition, in order to be able to secure your rights, before you can file a lien, if you're a second or a third tier claimant, as we talked about before, the subcontractor who is not in direct privity with the owner, then they must file a notice with the owner and the contractor within the first days of performance, advising them that they're performing work on the project. This is intended to not have a situation where someone who's completely unknown to the owner or the general contractor that they're going to be filing a lien and stopping payments on the project. So again, this is a unique aspect to the mechanics lien law. But if you find yourself in a situation where you're a sub of a subcontractor or a supplier of a subcontractor, before you even commence work, you should provide the requisite notice advising that you are a potential lien claimant under the mechanics lien law, because you are going to be performing work on the project. Similar to the situation with a construction lien, a private project, the lien must be recorded with the municipal entity. So again, the same do's and don'ts would apply. Make sure you're getting ahead of it and doing things timely, so you're not subject to whatever whims that may or may not be, restricting your rights with the municipal entity. And then the same things regarding who can file a lien, first, second, and third claimants, no suppliers of suppliers. Securing your bond rights. So a bond is a document that essentially it's a guarantee made by an insurance company and it's guaranteeing that the principal or the party who is secured by the bond will make payments to its beneficiaries. So it's what they call the tripartite relationship. The parties to the bond are the surety company, or their insurance companies, the party who is the principal, the general contractor in this example, and then its beneficiaries would be any parties who have a contract with the principal and who are unpaid. So a payment bond would be what this is called, and the payment bond would guarantee payment to all of the general contractors, subcontractors, and suppliers. In order to be paid by the surety company under the bond, there needs to be a statement of claim submitted to the surety company and to the principal on the bond. In this example, we'll talk about the general contractor. What will the notice say? Well, it'll say that what services were performed, what amount is due and owing. It'll specifically assert that the unpaid subcontractor is asserting a claim against the bond, and it'll identify who the work was performed for. And sometimes it may be the general contractor directly if it's a sub of a sub, or if it's a subcontractor of the general contractor. But if it was a subcontractor of the subcontractor, then the statement would need to identify that. Regarding the actual timing of filing the claim, it needs to be filed. There's no specific time frame, but given the lawsuit deadlines, it should be filed as soon as possible, because no suit can be brought until after 90 days after the notice of claim. So if you file your claim, on the verge of that 1 year deadline passing, then you won't be able to file the lawsuit in the time frame that it will be required. So all lawsuits must be filed within 1 year from the last date of actual work or delivery of materials from the project. And the lawsuit will be brought against the surety company and the party who is bonded by the surety company, the principal. But if that lawsuit's not brought within that year time frame, then you will lose your rights under the bond. And again, as I mentioned regarding the 90 days, if you file a statement of claim, you can't the next day file a lawsuit to under the bond in order to get paid. You must wait 90 days, and the 90 days is intended to give the surety company time to review the claim, to speak with the principal on the bond, the general contractor in this example, and ultimately determine whether or not payment is due and owing. Bonds aren't automatic payment. They allow the surety company to investigate whether or not payment is due and owing, and if for some reason payment isn't due and owing, they can assert the defenses of the general contractor and deny the claim. They could also deny the claim for being untimely or for not following the requisite requirements. So, again, it's very important that the statement of claim to the surety be provided to the surety company and the general contractor in that, in the first half of the year, ideally. And then if the resolution, if the claim isn't accepted, then the lawsuit's going to need to be filed, as soon as possible, and obviously before that year deadline. Consistent with the lien law, regarding the bond law, again, there are restrictions regarding second and third tier claimants. Like the municipal mechanics lien law, prior to commencing work, a second and third tier claimant must provide notice to the bonded contractor that they are a beneficiary under the bond. This is going to prevent a situation where, again, they're going to be where the contractor could be surprised by someone they don't even know is doing work or supplying materials to the job. So if that notice is not supplied before commencing work and you fall within those categories, then you're potentially subject to losing your bond rights. So it's very important that notice be provided. I should mention, regarding the bonds we were talking about, that the bonds in those situations are most typical on public improvements, because going back to the municipal mechanics lien, you don't have the ability to foreclose on property, but what you do have the ability to do is file the mechanics lien. And there's also a requirement in the state of New Jersey that every public project be bonded. So if you're doing work for any public entity, then there will be a payment bond to seek recourse against. It's statutorily mandated. That doesn't mean that there won't be bonds on private jobs. There certainly could be, but it's not required by statute. So even if you're doing work on a private project, consider the fact that there may be a bond, and that bond may be a way for which you to get paid. You won't know unless you ask whether or not there's a bond. So if you're a subcontractor doing work for a general contractor on a private improvement, you should ask whether or not there's a payment bond securing all payments to the subcontractors and suppliers on the job. If there isn't, then again, there's no harm, no foul, because there's not a statute requiring it. But if there is, then it's another way that you could seek to get paid. And if there is a bond, it's going to be very important to get a copy of the bond, because the language in the bond will actually tell you what requirements need to be met in order to get to file a claim under the bond. So just to recap regarding the bond statutes, you have the public improvement bonds, where there's always going to be a bond on public improvements, and these requirements are applicable. The statement of claim, what needs to be in it, kind of basic, but identifying to the surety and general contractor who did the work, what's owed, and that there's actually a claim being asserted. The time components within 1 year from the last date of work must wait the 90 days. And then if you're a second or third tier claimant, you need to file notice before performing work in order to ultimately get paid or to have a valid claim on the bond. So traps to avoid. Regarding lien traps. So in pretty much every municipality in the state of New Jersey, I haven't seen one that doesn't use this, but there's a cover page that must accompany all liens that are filed. If that cover page is not included, then the municipality will flat out reject the lien. So it sounds like a technical defect, and it certainly is, but it's a technical defect that could cost you greatly. If you send a courier to go file the lien without the cover page, well, the couriers are going to come back, charge you for the delivery, and most importantly, be unable to file the lien. This dovetails into the next trap to avoid. Don't wait till the 90th day. For the reasons I've already discussed, if you wait too long, you run the risk of, for one reason or another, not being able to timely file a lien. And if it's not timely filed, then you won't be able to secure your lien rights. Don't include unapproved change orders in the accounting. I already mentioned that if the accounting includes change orders, like the example I gave before about the retaining wall, where there's just a handshake deal on building the wall for $10,000, and there's not actually anything in writing to that effect. Well, that amount can't go in the lien, and going back to the contracting example, it may be something you were going to have difficulty even proving entitlement to in the first place because of the fact that it's a he said, she said type of argument. So, not only is it important to have written change orders, but if you do have unwritten change orders, be sure not to include them in the lien accounting, because if you do, you run the risk of having an overstated lien, and if the lien is overstated, then there's a basis to discharge the lien entirely, and it could subject you to liability under the statute for an overstated lien, which could not only, like I said, get rid of the lien, but actually it would subject you to liability for costs and fees by the owner to remove the lien. So, don't include unapproved change orders. Only include approved change orders that are in writing. Lastly, be sure to use an accurate last date of work. Given that the last date of work is a common theme for both lien and bond rights, I'll talk about this regarding traps to avoid on bonds as well. But the last date of work for both liens and bonds and calculating your deadlines, it should be dates where work was actually performed, not warranty work or work to go correct something that was or corrective work that should have been performed already, or something that is just intended to ultimately extend the deadline out. What they're trying to do is avoid someone going back and doing work that is solely intended for that purpose, just to extend the lien rights. So the last date of work should be as conservative as possible, and it should be work performed under the contract, not work, like I said, that was warranty work, or punch list or corrective work. That those categories of work, if you're relying on that date to make the lien timely or the bond claim timely, then you're most likely going to face a argument from the other side that that work does not constitute work, and that your lien or bond claim are untimely. So I'll repeat that again. Use work that was performed under the contract, not warranty work, not punch list work, and not corrective work. Bond traps to avoid. Again, don't forget to send the pre-performance second and third claimants the pre-performance notices to the bonded contractor. Don't wait to send the notice. Send this notice as soon as possible, because if you don't send the notice before 90 days from that year from the last date of work, you run the risk of not being able to file a timely claim against the bond or a lawsuit against the bond. And as I mentioned before, use an accurate last date of work for materials and or work delivered to the project. If you don't use that accurate date and you use things like warranty work, punch list work, corrective work, then you're likely going to face an untimeliness defense. The Prompt Payment Act. So New Jersey has a statute which specifically requires owners and general contractors to make payments within specified deadlines. The first tier of the payment deadlines is between the owner and the general contractor, and the statute requires that the owner pay the contractor within 30 days after the date of billing, but that's unless the owner provides the general contractor with an explanation as to why payment is being withheld within the first 20 days. So if a payment requisition is submitted on the first of the month, then the owner will have until the 20th to sent a notice to the subcontractor or to the general contractor in writing explaining why payment is not being made. If no such notice is made, then under the statute, payment is deemed due and owing to the general contractor. And that obviously is very important because it will be a argument that the general contractor can assert against the owner under the statute if after not making payment, the owner tries to claim that there are bases to withholding payment. The statute may be a mechanism that could be relied upon to seek the payment, saying that the payment is deemed due and owing because no notice was provided, payment is due and owing under the statute. And if they violate that statute, the owner does, in not making the timely payment and doesn't provide the requisite withholding notice, then it's a violation of the statute, and attorney's fees, interests, and costs can be recovered by the general contractor. As it relates to payments between the subcontractor and general contractor, the general contractor must pay the subcontractor within 10 days of receiving payment from the owner. So if the owner pays a general contractor, then the general contractor must pay the subcontractors that are owed money from the payments received within 10 days. If the general contractor doesn't make that timely payment, then the general contractor will similarly face liability for interests, attorney's fees, and costs. Another interesting mechanism that the Prompt Pay Act provides is if payment is not being timely made, then the general contractor, subcontractor, they can send a notice upstream to whoever their contractor or owner is, advising that they intend to suspend performance if payment is not made within 7 days. And if after 7 days no payment is made, then the contractor or subcontractor, depending on the circumstance, can suspend performance without penalty until they're timely paid. Again, this is a circumstance where payment would have to be due and owing. It can't be a situation where if the owner advised the general contractor why they're withholding payment and there's a dispute over whether or not payment's due and owing, that the contractor sends a notice to the owner saying, I'm going to walk from this job and suspend performance. It's a situation where payment is not made and it hasn't been timely objected to. So it's another leveraging point that could ultimately help the subcontractor or contractor, depending on the circumstance, get paid. Because obviously if the project's not progressing and there's a valid suspension of work by the contractor or subcontractor, the only way that performance will resume is if payment is made. So it's definitely a unique tool. It can only be exercised in certain circumstances. It shouldn't be, in no way, shape, or form should it be used liberally or in its face of a disputed amount that's owed. But if the right circumstances present themselves and you can definitively provide the written notice and payments not made, then yes, suspension of performance is available. Lastly, the right way to exchange a release for a check. So now we're at the point where payment's going to be made and there's a check in front of you, and in a typical situation, if you're a subcontractor, the general contractor is also going to ask that, in addition to accepting the check, that you're going to sign a lien waiver or some sort of release, and that document will essentially say that you're acknowledging receipt of payment of the amount due and owing, and in exchange for that receipt of payment, you're agreeing to release all claims against the general contractor for the work performed up to that point in time. Well, one thing to consider is if prior to that payment being made, there may or may not be some disputes regarding things that, disputed change orders or work that was performed that they're calling corrective work that you're calling additional work. If there is disputes that are outstanding prior to accepting that payment, and you haven't been paid and you're not being paid in that check for in connection with those disputed issues, well, you need to make sure you preserve those disputes. So one thing to do, and it's very typical in a lot of lien waivers, where there's a carve out that says that you're releasing all claims, and then it'll say accept, and you can write in the lien waiver what you're not releasing. That should absolutely be used by any contractor or subcontractor who's signing a lien waiver. And if there are disputes that precede the payment being made, and again, if that payment is not compensating for those disputed issues, because if you sign that release, you sign that lien waiver, and you agree that all prior work, you release all claims in connection with all prior work, well, there's a strong argument that you're releasing those disputed claims, and that your acceptance of payment at that time, when those disputes are preceding the payment, are going to be included with the payment, and you will not be able to, you'll forfeit your rights under those disputed claims. So be sure before signing a lien release to carve out any disputes and specifically identify them as not included in the scope of the release or waiver. Obviously, regarding the scope of the release, make sure you're comfortable with the language in the release, and that you're only, releasing claims that you're comfortable releasing. And lastly, another way that you could potentially jeopardize your rights to recover amounts that are not included in the payment is if somebody who cuts you a check puts in the memo line full and final payment, or in full satisfaction. This simple language would represent that your acceptance of that check and putting that check into your bank account is agreeing that that payment is paying for all work performed, and it's encompassing all prior disputes and also just prior amounts outstanding as between the recipient of the check and the party cutting the check. If you see that language and it's not intended to be full and final payment, or it's not intended to be in full satisfaction, rip the check up. Do not accept it, reject it, and definitely do not cash it. If you do, you run the risk that that payment received will be deemed full and final, and that any future payments that you would have expected to receive will not be received, because your acceptance of that check would have essentially released those other claims. All right, so at this time, I know we covered a lot. I'm sure you may or may not have some questions related to the contract, to lien rights, to the bond rights, and to the process of accepting checks. So if you have any questions, I'm happy to answer them.
Well, first of all, Kyle, thank you so much. That was a great webinar. You went over a lot of really good information. As far as those releases, just really be clear of what you guys are signing away. So read it. We do have a question that has come through. It says, can I include my attorney's fees and filing fees when I enter in the cost of my lien?
No, in your lien, you should just include the amounts that you are due and owing under the contract. So don't include attorney's fees and costs.
All right, perfect. And then it says, is a bond required to be recorded on a private job?
It's not recorded like a lien is, but the bond is something that will absolutely be there. And if you don't have the bond, there's a couple of things you can do. One thing, if you're a subcontractor and you're performing work on a public project, you can ask the general contractor for a copy of the bond. If they don't give you the bond, then you can also submit a request for the bond with by a OPA request to the municipality or the public entity. All public entities have the Open Public Records Act as a mechanism to get information. They will have a copy of the bond, and they will be required to give you a copy of the bond if you submit the OPA request. So even if you're doing work on a job and you don't have a payment dispute as of yet, it's not a bad idea to get that copy of the bond in one way or another, whether it be through just again the general contractor giving you a copy, or they're getting it from the public owner.
Right. I mean, if you can get the copy of the bond early on in your project before there's any kind of a payment dispute, it will just help you to better prepare yourself of what you need to do in order to have that bond claim. All right, that's all the questions that I see that have come through so far. If you do have any question that wasn't addressed, please feel free to reach out to myself, to me, or to Kyle, and we'll be sure to answer any questions as soon as possible for you. Can you go to the next slide for me, please?
Sure.
All right, so here are some resources we have. Go ahead and scan that QR code. It's all the resources at SunRay Notice on our website. So we have deadline calculators, project information sheets that will help you guys stay organized, know who the participants are on your job, all the different details, ask the relevant questions early on. If you're working in a nearby state, remember each state has their own set of lien laws and deadlines and documents that are required. So go ahead and check that out and know what you are needing to submit and when. So please go ahead and scan that QR code to get those resources. Next slide, please. If you don't mind, scan this one just to give us a review on Google. We really appreciate any of the feedback you can provide to us so we can get better information out there, different topics that you're interested in learning about lien laws and the different rules and everything associated with them. We'd appreciate that. And then the next slide for me. And with that, that is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you guys at our next webinar. Again, thank you so much, Kyle. You were incredible. I hope you all have a wonderful and beautiful sunny day.